Thank you.
Thank you, Your Honor.
All right. Wilmington Savings versus AmTrust Title.
Good afternoon, Your Honors. May it please the Court, Eric Mandel for the Plaintiff Appellant, Wilmington Savings Fund. Your Honors, there is a surprising absence of case law involving the issues on this appeal.
Counsel, I would beg to differ. Court of Appeals in Plotch in 2016 said in the absence of a lien, the consolidation of two mortgages into a single mortgage equals the first mortgage of record. So, and I don't get it. I don't see why you say there's a dearth of law. And even if you look at the second department, a title insurer's liability to the insured is based on contract law and limited by the terms of the title insurance policy. Here, the condition 2 of the AmTrust policy said that the policy remained in effect only so long as the insured, and this would be the Rosa mortgage, retains an estate or interest in the land. At the point where you have a consolidation of the two mortgages, the Gap mortgage and the Rosa mortgage, Rosa disappears.
Your Honor,
Subsumed.
I would respond.
Better word than mine.
Well, Your Honors, the plain language of the policy defines the term insured as the owner of the indebtedness or the successor of the indebtedness, which means the assignee. In this case, the underlying mortgage that was insured by AmTrust was assigned and not satisfied, which was the basis of the claim denial.
It was subsumed by the consolidated mortgages, so it no longer exists.
There is case law that says that where a first mortgage is assigned, and I've cited it in the brief, that where a first mortgage is assigned and consolidated with a new consolidated mortgage, that first mortgage retains its independent lien status. There's nothing within this policy that says when a mortgage is assigned and consolidated with
When
the
this
subsequent...
consolidation took place, there was a new insurance policy on the new $3 million consolidated mortgage, no?
There was.
Okay, so why are we here? Why, if you have already an insurance on the entire note, why is your client trying to access insurance for the same amount? You cannot get more than the $3 million that is already there.
No, we are asking that two policies of insurance be put in, that two
But they
policies...
have to be active, and they weren't after the consolidation.
There is nothing in this policy at this point, on a pre-answer motion to dismiss, there is nothing in this policy that
Except
says...
the language of the policy?
No, in section 10B, it says liability under this policy terminates upon a satisfaction. It does not say upon an assignment. And if there's any ambiguity within the policy, it is construed against the insurance company. The term
Counsel,
insured specifically...
You mentioned the case law that you cited. However, the case law that you cited, they're distinguishable from this case because those cases didn't involve consolidated mortgages.
I believe Benson did involve a
Not
consolidated
one of
mortgage.
your cases involved a consolidated mortgage.
Your Honors, there...
Not one of them. We read all of them.
holding in that, if I may,
The holding has to apply to the facts that are similar to this case.
There is no-
And there was not a consolidated mortgage in the cases you cited.
there is no case on point. In this,
Ah.
in this state,
And there lies the rub, right?
if I
So
may,
you want us to, what you want us to do is take those cases that had nothing to do with a consolidated mortgage and apply that holding to this case. That's what you'd like us to do.
that is what I'd like the court to
Yeah.
do. And if I may, to adopt the defendant's position would result in a determination that every time a mortgage is assigned and consolidated, the prior title policy terminates. There
It
is,
depends on the language of the title policy.
and in this case, it only terminates upon a satisfaction and not an assignment.
Okay, let's go to the language. Let's just cut to the chase here. Let's go to Section 2A of the Agreement to Combine Notes and Mortgages. Under the law, the lender has one mortgage and borrower has one loan obligation. And we'll skip Section 3. Consolidated note will supersede all terms, covenants, and provisions of the mortgages. Section 4. The consolidated mortgages will supersede all terms, covenants, and provisions of the mortgages. Also, Section 4, the consolidated mortgage serves as a consolidated note and will constitute in law a single lien on the property.
I don't disagree with any of that,
Oh,
Your
so
Honor.
then why are we here?
But I do look at the four corners of the document, and there is nothing in the title policy that says that it terminates upon an assignment and a consolidation.
Except that language. You'll have time on rebuttal.
Afternoon, Your Honors. Jeffrey Metz for the Respondent. Your Honors, I'll rest on my brief unless the court has
Yes,
any.
smart man.
Very smart, very, very smart.
Thank you. You have 1 minute.
I would like to refer the court, if I may, to the title policy, section 1EC, which says that the term insured, in addition to being a successor in ownership, says a successor to an insured by dissolution, merger, consolidation, distribution, or reorganization. Now, whether that means in terms of a business dissolving or being consolidated with another business, that's an issue of intent. This was a pre-answer motion to dismiss. That language alone creates an issue as to whether an insured remains an insured despite a subsequent consolidation.
Thank you. Cuomo versus James.